in session. The Honorable Ebony for 11.
Good morning.
Good morning. Good morning.
Ready to proceed?
Yes, sir. I'm sorry.
Will you be making rebuttal argument?
Yes, sir.
Show the jury in, please. Good morning, folks. All please be seated. Ladies and gentlemen, will you now please give your attention to Mr. Owens for rebuttal argument on behalf of the plaintiff.
Thank you. Morning, ladies and gentlemen. You're probably not as nervous as I am, so that's okay, but you're probably pretty happy. Did it snow? No, we were asleep. But did it snow? Yes. That's circumstantial evidence. That's strong. It's common sense. It's in life's a lot of that. And this case has a lot of circumstantial evidence in it. And what does the instructions tell us on there? Circumstantial evidence and direct evidence, one is not stronger than the other. You can weigh it. You're the deciding factor, ladies and gentlemen. Not the state, not the defense. You weigh the evidence, you decide on the evidence, and you can decide that circumstantial evidence is just as strong or stronger than the direct evidence. Because it's not, you don't have to weigh it any more than the other. You weigh the evidence looking at the reasonableness, the opportunity, the common sense, the matter they testify, and the bias and prejudice they show. That's what you're going to look at. It gives you that in the directions. That's how you're going to weight that. And then you ask, is there reasonable doubt? Now, we heard defense attorney up there yesterday gave out that definition of reasonable doubt. And we have that in our jury instructions as well. Now, I'm not going to read everything about the reasonable doubt and what they talked about. But it spoke of, in instruction number 3, it spoke of the definition of reasonable doubt. And defense read that all to you and then stopped before reading the last line. It must have just been a mistake. They probably wanted to read that to you, forgot to read the whole thing to you. But that last line is it states, if from such a consideration you have an abiding belief in the truth of the charge, then you are satisfied beyond a reasonable doubt. Now, what is not reasonable doubt? Well, reasonable doubt is not no doubt. You do not have to find the defendant guilty. You can find the defendant guilty by not even going to no doubt. That's too high of a burden. Or beyond any doubt. That's too high of a burden. Because that's not it is. It's beyond a reasonable doubt. Where the 12 of you, or where you individually, believe the person through an abiding belief, a strong belief, the evidence is true, and you find it true, and you find them guilty on that, you've reached beyond a reasonable doubt. Now, the elements the state has to meet, there's several different elements in there. And that's on instruction 4, and we talked about several different ones there. The first one is that on or about December 29th. Well, we know December 29th is the date that this took place. We've heard hundreds of times that date being used. The police officers there, so that date's been met. And then it talks about the defendant acted with intent to cause the death of Sage Munro. So intent, and you see on the next page, okay, intent is the definition of intent, then that's just with an objective or with a purpose. And when you look at the defendant's actions from the evidence that the state's shown in this case, did the defendant act with an objective and a purpose? The state would argue, yes, he did. And we'll talk about that a little bit more and how those actions were. But the next thing we have to show is premeditated. Now, premeditated, the thought over beforehand. They thought about it. Now, it doesn't have to be 2 or 3 days, as it is in this case. As we saw him preparing, talking it over with Rex Lane, attempting to purchase a gun, driving there from Helena, Montana to Ephrata, Washington. It's quite a few hours there. Thought about it a long time. Came back, thought about it again, and started lying about it when asked about it. But again, we'll talk about that. But that's premeditated. He thought over beforehand, thought it over. And the evidence shows that here, ladies and gentlemen. He thought it over, he had an objective to do it, and he did it. That the intent, and that was number 2, the intent to cause the death was premeditated. That Sage Munro died as a result of the defendant's acts, which we've met that element. We've shown that with Dr. Fino, that Sage Munro had died as a result of a single gunshot to his torso, went through the left lung, heart, and right lung, and exited. And that caused the death. And he died most likely within minutes afterwards. And that any of these acts occurred in the state of Washington. And we know that the acts took place in the state of Washington because we heard Detective Dale state that Ephrata was in the state of Washington. And that's the reason I had him say that, because we had to meet that element. The state's going to argue it's met all of its elements. Now, we're going to get into and discuss why we have in using the rebuttal against what the defense said here. And we heard quite a bit of testimony or evidence or argument from the defense yesterday. 4 hours or so from the defense. Every little bit. But what you didn't hear after all that stuff is where I'm going to go to Ian Libby right now. This is Ian Libby's argument that he did it. But the state's argument, there's no evidence that Ian Libby did it. There's no evidence that 3 people were together. It's all talk. Nobody saw 3 people together. That being Latimer, Libby, and the gang dude. There's no evidence that there was any car prowling. There's no evidence that there's a gun kept in the car. There's no evidence that Libby touched the truck at all. So if there's no evidence that Libby touched the truck, how is it then that the defense is going to argue that the state lost the evidence to show Libby touched the truck? There's none. There's no evidence that Libby is even at the scene. There's none. Nothing. There's no evidence that Libby had a gun. Even on the 29th, that morning, because he wore a big thick jacket, there's nothing in there that says he had a gun on it. Didn't tell Tixon that he had a gun. Didn't tell anybody he had a gun. There's no evidence in this whole trial that Libby ever had a gun. No evidence that Sage Munro shot anybody, let alone Sage. There's no evidence there. Nothing. It's all speculation. It's all dealing with because he told somebody or possibly said something to somebody. And then it depends on who they told and if you believe that person. There's no DNA of Ian Libby at the scene. There's none. Well, we've checked. The state checked on that. Over this horrible, horrible investigation that you hear from defense all the time, that they just butchered this investigation altogether. They tested all types of people for DNA. They didn't find Ian Libby's there. They didn't find his prints there. They checked. There's no confession. The state's going to argue that. There's no confession into Ian Libby doing that, because Crystal Tixon said, I'm going to kill you like I did that guy. That guy. Now, if you believe Crystal Tixon, that the Ian Libby said this, what guy is he talking about? There's no evidence that she knows, because she may be thinking about that guy. There's no evidence that he said, yeah, I shot Sage Munro, or I shot Marita Messig's boyfriend, and he didn't see it coming. There's no facts of it. Only statement that Crystal Tixon says is he shot him, or he's going to kill her like he killed the guy. That's it. And then the other statement is what? To Nan Latimer? That, if I may remind you, we had the officer testify that Nan Latimer didn't say that when she was interviewed. She only said that on the stand.
Objection, facts not in evidence.
One moment, please. Mr. Owens, do you recall which witness you believe gave the evidence that you just referred to?
Detective Dale on rebuttal.
One moment.
Your Honor, Detective Dale did not testify in court.
I'll withdraw.
All right. That is correct. And the objection is sustained. The last comment regarding the absence of something from a prior statement of Ms. Latimer is stricken. The jury should disregard it.
But who counters that statement? Mr. Morrison. Mr. Morrison counters that statement. Jimmy Morrison says, I was there. He felt sorry for her. It shouldn't have happened to her. Shouldn't have been beaten. Shouldn't have been assaulted at all. But he never said that. He, being Ian Libby, never threatened to kill her. So ladies and gentlemen, what evidence do we have in regards to that? We have no evidence. No physical evidence. We have a statement that somebody's saying, some angry woman is saying about it. Is that the evidence that we want to say is going to stop or convict somebody? Gives them probable cause that they killed somebody because somebody's angry at them? The state's not saying that Ms. Tixon should have been beaten. It's not saying that. It's not saying she deserved any of that. In fact, Ian Libby, as I think we've testified to or made comments on before, is a pretty stupid guy. And if we wanted him out of our area and he's caused problems, he's been convicted of the assault, if we want to cause for any future problems, we can just go after him. Just try to drum up these charges. Go after him and say, because you said this, let's do this and just get him out of here. That's not how the system works, ladies and gentlemen. It has to be probable cause, it has to be proof beyond a reasonable doubt, it has to be evidence in there. And just because they make statements on there, there's no evidence that leads him and directs him to the scene. There's nobody. And the state would argue that if he tells somebody he did it, doesn't make it a confession. Because he says it laughingly to Nan Latimer, she says, it doesn't make it so that he's really doing it. Is really Crystal Tixon someone, the type of person that you heard up on the stand there, someone that's believable in regards to what she's talking about? Is her actions that day really believable? That she's afraid of this guy, that he really committed this murder? That she feels this way on the 29th December, that he did it, is what her testimony was. But yet she still goes out and buys him alcohol, buys somebody else Jimmy Morrison alcohol, goes out and drinks it, goes out and parties. We know what happened afterwards. We know the comments that were made. And then only after that, they testify that, well, she told that comment to Laura Hayes, and Laura Hayes then went and told the police. And the police didn't do anything about it until she even, called the tip line. But she specifically said she went to the Ephrata Police Department and told them exactly that he's a suspect, that he did it. And the police didn't do anything about it. Ladies and gentlemen, when the police found out about it, Officer Powell, what did he do? He immediately contacted Detective Rodriguez. The state would argue with you that that never happened. That Laura Hayes never went to the police department and told the Ephrata Police Department that Ian Libby was a suspect, because the police would have done it. As soon as the police heard about that, they contacted Detective Rodriguez. And the investigation started there. Now, should have the investigation should have started earlier with the tip line? Yeah. There's a mistake made. No doubt. That's what the whole idea of the tip line's about. But what evidence did they lose from that? They still found out who they spoke to. They still found out who the tip was from. They still spoke to the person. They still interviewed the person. They found that information. They didn't lose that information. And when they interviewed Crystal Tixon, who'd they go interview? The defendant. Not the defendant in regards to David Nichols, but Ian Libby. As the defense wants you to think Ian Libby is the suspect here. They went and spoke with him, because that's what police do. And they did. And they interviewed him, and they found an alibi. And they went and talked to this person. Now, Tasha Deviat, which story are you going to believe? You're going to believe the first one, the first day, handwriting, where the police sat there, they interviewed her, they wrote it out, she's right there, she signs it, she leaves. Or the one that takes place 2 years later, that's interviewed in Wyoming, where the defense attorney interviews him, leaves, comes back 2 months later with the sign, or having to sign a statement. Sometime later. She couldn't tell you exactly 2 months, but it's sometime later. Doesn't know. They didn't do it right there on the scene. And she just signs it. Or the third one, when the police went back to her, interviewed again, taped interview, to get a statement. And she said, I was telling the truth the first time. I was telling the truth the second time. I was telling the truth the third time. You can't do that. You can't tell the truth every single time when they're completely opposite of each other. So what are you going to do with her testimony? Well, what corroborates her testimony? Her mother, Amanda. Amanda says, I went there that morning on the 29th. Ian Libby was there. He was there in the morning, said he was there. I opened the door, there he was. Then he left her later on that morning. Then he came back later that night. She didn't give 3 or 4 different statements. She just corroborated it, didn't answer it. But Ian Libby was there. We hear Ian Libby that he's running around trying to contact witnesses and get alibis and tell people that. We hear defense tell about Cox, Mr. Cox, that when Ian Libby comes to his house, we hear the defense yesterday talk about, well, Mr. Cox, Mr. Libby sitting there on Cox's couch crying, saying he doesn't want to go to jail or doesn't want to go to prison. What did defense forget to tell you? Mr. Cox testified that Ian Libby was sitting on the couch crying, saying he didn't want to go to prison for something he didn't do. The defense is about to tell you about that statement, the full, complete statement. Because why? Because it goes to the heart of what Mr. Libby is saying about it. He doesn't want to go to prison for something he didn't do. He's running scared. He's not the brightest guy in the world. We've seen his actions when he gets upset, when he gets scared. But there's no actions in regards to guns. There's no anything about guns in there.
Your objection is to improper argument having to do with earlier rulings on evidence.
Objection is noted. Go on.
Now I want to go to the crime scene. Let's talk about the crime scene in regards to these footprints. You saw the photograph up there. Shows you the footprints by the back, where the footprints go around and they have the little paint in them, circle. It shows you the direction, it shows you the footprints. And then you see footprints in the right-hand corner as you're looking in the backyard. Excuse me, the other right, the left-hand corner. And you see 2 footprints there. And that's all you see. Now, what you do see is footprints leading to the right. Those are the ones with the red circles, right? We see those. Defense wants you to believe there's a path to the left there along that area where those footprints are at. Ladies and gentlemen, there was no path footprints going there. There were 2 footprints at the end in that corner, but there was no path. There was not 2 people going up unless one of possibly 2 things happened. That there are 2 people doing the shooting, and then after the shooting, one person carried the other person, carried him around that area there, and then dropped him off over there in the corner. Or maybe the person got on the trampoline, jumped on the trampoline and dove over to that corner and then jumped over there. Because otherwise, there's no evidence whatsoever that shows that there is another path up there. Nothing. The police testified those were the paths they saw, and they circled it showing the path where they were going at. Certainly there's 2 footprints out there. There's that one there in the corner and one over there. It appears to be fresh. But not leading is taking off. One set going out. One person. One shooter. That's it. The evidence is wrong. The defense is arguing about it. It's not there. How about the crime scene itself? Is it a bad crime scene? Was it really bad in regard to how they controlled it? You saw the photographs. They photographed the scene. Now, you're talking about no footprints from Mr. Munro. Ladies and gentlemen, Mr. Munro was laying in his house bleeding, not knowing if he passed away yet or not.
Objection, facts not in evidence. An improper argument.
Objection is overruled.
Lying in his house, not knowing if they're, what are they going to do? They called EMT, they called first aid, people going to get there. What's the last thing those first aid people are going to think about? Let's cover up, let's not mess up these footprints. What are they thinking about? They're thinking about, let's get into that house, let's save this guy. But once all that had happened, and they realized they couldn't save Mr. Munro, they left. They got out. Now, was there a lot of footprints in there? Yes, there were. Because we heard the evidence of who showed up, quite a few. And they couldn't distinguish. But that doesn't mean Mr. Munro's footprints weren't there at one time. We saw a lot of footprints in there. And even the defense's witness, expert witness, Mr. Sweeney, said, well, yeah, I just didn't see them. Doesn't mean they weren't there at one time. They could have been covered up, couldn't it? But he just didn't see them there. Just because he didn't see him there at one time doesn't mean he was. And how do we know that those footprints were probably there? Because the state listens to witnesses when they speak. Not trying to ignore them to the best of what their idea may have happened. We listen to the testimony of witnesses and what they saw and what did they see. Mrs. Colleen Gibbons says that she saw Mr. Munro by the back of the pickup, bent to a bent, grabbing, and then went back to. Now, when we asked Mr. Sweeney, did he take that into account? What was his answer? No. She could be wrong. Well, because that doesn't fit what he comes to. He says the person is at the bottom of the stairs when they were shot because they have to cough immediately. Immediately. Even though different lungs are different sizes. Even though Dr. Fino, a medical doctor, pathologist, has performed how many, thousands of autopsies, says she could not tell us how long it would take for the lungs to fill up. She had no idea. It depends. Too many case scenarios on it. But Mr. Sweeney certainly could, couldn't he? But what couldn't Mr. Sweeney do? He couldn't give us a report to say how he came across that. He just comes in and tells us this information because lungs, they fill up. Well, yeah, we know. If somebody gets shot, they're going to fill up. But how long? How fast? How long would it take someone to cover that distance if they ran from the back or from the corner of that pickup over there to the front? Not very long. Not very long. Is there going to be a splatter from the gunshot wound out? No, because there's clothes on. That's going to absorb any splatter in it. So this is, Mr. Sweeney says, is from cough. Doesn't make sense. Mr. Sweeney spent, what did he say, over 100 hours on this. Looking at photographs, analyzing it, never went to the scene, never did measurements or anything, never did any reports, but then comes back and wants to be an expert in regards to, this is why we do it, but we're not going to listen to what Ms. Gibbons says. Ms. Gibbons is the first person that sees it all. Mr. Sweeney's testimony, ladies and gentlemen, is not reliable. In his testimony, wasn't it happened there? What was his testimony? It's likely that it happened. It's a guessing. That's what he's doing. We know for a fact that in regards to the wound of the Mr. Munro was left to right, shoulder going down in a downward angle at 5.5 inches from entrance to exit. And it took 13 inches to get there. So let's give it the best case scenario. Every 12 inches, we know it's going to go down 5 inches, correct? We know there's not standing right next to him when he shoots because there's no powder burns. There's nothing of that nature. So if we have to get back far enough to where the angle is going to be at 5.5 inches, even if the person's 6'1", they're going to have to be up on a ladder in order to get that. They're going to have to be pretty tall up in order to meet that direction to get back far enough in order to make it 5.5, an angle at 5.5 inches down at 12 inches. Because think about that each time. You can do the math back there if you wish, how far they'd have to be and how tall they'd have to be, or what's the angle on it. Now, from that, there's one of two things that could have happened. The shooter is elevated, and there's places around there that puts a shooter elevated. And now we know where the cartridge is found, correct? We know it's found on the south side of the walkway. And we know that it's so many feet. It looks distance-wise. You can tell in regards to that. And it's about 13 to 15 feet, we're guessing, from that cartridge to the tree. And we also know, and you'll look at the photographs in there, all that area around that tree is elevated. Could a person surprisingly come out of there and shoot somebody? Now, when we heard the defense expert testify the extraction of the round, if it was perfectly fired, as perfectly with the up and down handgun, the round is going to go out 13 to 15 feet. Perfect, in a perfect world. Anybody has done any shooting in there, as a 45 or any automatic, it has its own world. Sometimes I know some people have shot that it's went down their back on a cartridge and stuff. But it also depends on how you're holding the gun, where the cartridge is going to come out on an automatic. The automatic comes out the side, it shoots out. How about if you have your gun tilted, as we see everybody holding their guns anymore, coming out, shooting out, the gun's tilted. Where's the ground going to go then? Up. Is it going to go 13 to 15 feet? No. So it could be a little bit tilted less. So there's so many possibilities of how the gun was held, what was going on. It's not for sure the distance of where the shooter was at when it took place. But we do know, elevation-wise, to come down. The second theory, ladies and gentlemen, is, as Ms. Gibbons says, she saw the victim crouch in a crouched position, holding his chest, down like this. He's down in a down angle. Could that have been cause for the angle shooting down? Certainly it could. Now, there's no evidence 100%, but circumstantial evidence when you look at what's going on. Now, it doesn't meet what I believe Mr. Sweeney did say the victim could have been crouching, yes. But not the position or not the location. Because he puts him in the location because he says he automatically has to cough. And it has to extract it in there. Well, the coughing, if you look at the photograph there, is on the stairs and coming this way here. And not over here where he would be turning around, if he turned that way. I invite you to look at those photographs in there for the scene, to look at them. Could a person move there in a second or 2 seconds or 3 seconds? Yes. He could. And the state would argue that Mr. Munro was shot. We're standing close to that pickup as Ms. Gibbons saw. Let's talk about the real defendant in this case, the person who committed this crime, and that's the defendant, David Nichols. As Mr. Hill pointed out, Mr. Nichols had motive, opportunity, and he did it. The evidence shows that. Now, we heard a lot of testimony from defense attorney about why would somebody say they...
Pardon me, Mr. Roman. Objection is to defense attorney testifying. No defense attorney has been called as a witness.
I think counsel misspoke. The jury has been instructed that what the lawyers say is not evidence. Go ahead.
Thank you.
We heard defense argue that if a person says something, it has to be so. Why would somebody say they did something and it wasn't so? And where was he arguing that at? With Mr. Libby. So we'll take that argument and put it with Mr. Nichols. Mr. Nichols in a bar. He tells Mr. Alsager, before any police has ever talked to him, before any information is out to the news, the only person he's spoken to, is evidence shows he's spoken to, is Marita. And does she know any information about the killing, of where a person was standing, how it happened, where their wound was at? If it was a sneak attack or not? No. She doesn't have any of this information, because the police doesn't give that information out. So they're in a bar, he's drinking. How many people has ever had a few drinks and they said, oh man, that made your lips a little loose, I shouldn't have talked about that, shouldn't have said that. Things happen. Mr. Nichols is at the bar that night, and he confessed. He confessed in detail to Eric Alsager. Now they're saying, how can that be? It's a noisy bar. They can't hear what's going on. They had the music playing. Nobody could hear. Well, the bartender himself said, well, yeah, if you're sitting right next, you could. It was just you couldn't hear if you're standing away. If he's standing at the edge of the bar and sitting there, he probably couldn't hear it from what he said. But there were people who did say they could hear it. And that was Mr. Kleeman. He said he could hear that night. Miss Stanky, she said she could hear that night. And Mr. Earp, he said he could hear that night. They said they could carry on a normal conversation. They could hear fine. So, we have 3 people, 4 including Mr. Alsager, saying, yeah, we could hear it. Making a confession. So what's the confession? Well, I'm being investigated for murder. How does he know he's being investigated for murder? Nobody's ever told him that. Nobody ever said that. Nobody's come and talked to him yet. Rita Messick didn't tell him that. He knew he was because he did it. How do you know he shot in the chest? He said, I shot him in the chest. He didn't know it was coming. Ladies and gentlemen, that's exactly what happened. He shot him in the chest, and Mr. Munro didn't know it was coming. He was going out that morning to go work out, and boom, shot. Surprise. Over what? Over a girl. It's not the first time it's happened. Unfortunately, it won't be the last, but it did. Unfortunately, it did happen. Now, how do we know it's David Nichols? Well, we go to his confession. But let's go with let's go back to the scene. We heard defense say David Nichols didn't do it because they couldn't put him in Ephrata. Yeah, we could. His DNA's there. State argues his DNA's there. It's included in that. We saw the description of that, how that DNA is included. Now, certainly, we heard the numbers that, what's the possibility of it being Mr. Nichols and stuff? Okay, then let's do this. Let's say His DNA's there. What's the possibility that Mr. Nichols then, a few weeks later, tells people in Montana how it happened? Would that be circumstantial evidence that would raise the possibility that Mr. Nichols was there? Certainly it would. Because who else would? Nobody else's DNA. Police checked everybody's DNA in there. Checked it. All the suspects in there. Officers in regards to there. Even shown that one officer on the bullet sneezed or had a cold or something there, and his DNA was on there. Made the officer look bad, but still, we're not going to hide that. That's what happened. But they checked the officers on the handcuffs as well. No. So then we have, again, this DNA, the confession, and him trying to get a 22. Now, do we think it was a 22 that did it? No, we don't. But he's trying to get a gun just right after they split up and just before it happens. And then let's add Rex Lane. Rex Lane comes across there and starts saying, yeah, he talked to me all the time how to do it because he knew I did it. Didn't really want to talk about it, but I'd tell him how I did it and stuff. And then he asked me how to do it, if I would do it for him. And he offered me money. What's the chances of that, ladies and gentlemen? What's the chances then in circumstantial evidence that, oh, we're just picking on David Nichols? The evidence is keep going there. So we get a hold of David Nichols. Mr. Nichols, please tell us. Where were you? What were you doing? This is before the phone records. Tell us, what were you doing? Oh, I was with Rex Lane. I was with Rex Lane on the 28th and 29th. What's Rex say? No, you weren't with me. Sorry. Oh, okay. Well, where were you? Great Falls. Yeah, maybe. I'm not sure. Does that add a little bit more circumstantial evidence? Now does that DNA at the scene and him confessing and Rex talking to Rex Lane and trying to get a gun, does that get a little bit stronger case now? And then we talk to Marita. Marita says, yes, she calls him right afterwards, says he was in Great Falls because she suspected he did. Doesn't know. The detective does a good investigation, very good investigation. He starts getting all these phone records, checking this, checking that, who's there, the cell towers, all this stuff. You think David Nichols knew about that? Possibly, possibly not. But what did it show? It showed that on the 28th, he gasses up and he takes off to Washington. He has 40, 50, I don't know, quite a few calls. We had the guy who did the map for us, say how many calls he had. Quite a few calls that day. Then at 10 o'clock, so quits on the 28th. Doesn't start back up until 8. 2 hours and 11 minutes later, 8:51, something like that. And the murder takes place around 6:30, possibly. The call takes place at 6:41. But she doesn't call a minute later, does she? What does Miss Gibbons do? She runs across the room, or across the street, tries to see what he's there, doing this, doing that, and then comes back. About 10 minutes passes up. And it doesn't take 2 hours and 30 minutes to get from here to Spokane. It doesn't. And the snow, as little as it snowed that night, snow's not going to be on I-90. That's common sense. Anybody who lives around here knows it's not going to be. It's going to take a little bit more on snow to be stuck on there then. The defendant drove there. Then he gets that phone call. He admits getting the phone call. Yeah, I got it from him. Says he was in Great Falls. Was he in Great Falls? Not when the investigation comes out. He's in Spokane at the time he receives a phone call. Why would somebody say they're in Great Falls, Montana, when they're in Spokane, Washington, hours away from a murder scene? And we know the defendant knows where Sage Munro lives because he's described it to Maria, to a T. We know he knows where Moses Lake is at because he stayed there. Even though he didn't tell the police he stayed there. He said he stayed in Wenatchee. He said he stayed in Spokane with her. Didn't say anything about Moses Lake. Look at each and every one of these elements, ladies and gentlemen. Look at each and every one of these actions. Is it adding a little bit more circumstantial evidence? Is it getting a little bit stronger? Or is it just some coincidence that, he's just a liar, we gotta ignore him? And he's interviewed once again by Detective Rechtenwald. And we heard his statements up there where he's talking about, okay, where did you go? Help us out. Where did you go? You got gas at the Cynics. Where did you go? For a drive. What do you mean for a drive? Where to? I don't know. It was a nice day. He doesn't remember where he goes, but he does remember it's a nice day. Is he lying? Is he avoiding the question? Is that something that would be reasonable to look at, ladies and gentlemen, when you're looking at his actions? Does it add to circumstantial evidence? I mean, when he's asked, okay, were you in Washington? I didn't say I was in Washington. Well, ladies and gentlemen, we don't have to know, because number one, he never told anybody. During those interviews, he gave the phone to anybody. He didn't say anything, he gave the phone. So we could say he has his phone. Because how do we know he has his phone? He admitted getting a call from Marita. Didn't he? He admitted that. So he has his phone. And the phone record shows that he was there. So he was there. So he doesn't want to admit anything. He doesn't want to say anything and won't give any where he stayed, what he was doing. Defense argues he's in a legitimate business. He can go anywhere he wants. What legitimate business? What evidence does it show that it's a legitimate business? There's lots of business that goes on in the second-hand places that aren't legitimate. There's no evidence that it was a legitimate business. Ladies and gentlemen, the state's arguing it's reasonably inferred that the defendant is guilty. Guilty is charged. Looking at that evidence, it's overwhelming. So we would argue it's overwhelming. It's not a little guesstimate. It's not saying, well, let's just pick, Ian Libby out. He's a bad guy. Let's just arrest him and charge him because he told somebody once he did it. It's all the pieces of the evidence that keeps adding up. His past actions, he threatens Barbara's family to Marita, saying, if you don't do this, I'm going to kill you. Their family. Burn it down. He doesn't argue. He doesn't threaten this time. He just does it. Just does it. Over what? There's too many lies, too many deceptions. The evidence shows that the defendant there's no evidence, ladies and gentlemen, that Miss Marita Messick ever got back with the defendant after the shooting. None. She called. Certainly she called. State's arguing she told because she wants a confession from him. But she never got back with him. Never did. She may have loved him. She's since lied, but she was no longer in love with him. She fell in love with Sage Munro. Now, he's the father of her child. He's going to be around sometime the rest of his life. Certainly. She loves him. She's done. But who didn't want that to end? We heard a lot of half-truths, half-statements, half-arguments in regards to the evidence by defense on this. Defense may argue the same thing about the state. But you, ladies and gentlemen, are the bearer. It is your job to weigh the evidence. And there's a lot of evidence out there. Look at the photographs, look at the videos, look at the testimony. They would argue that then you will find that the defendant sitting there, David Nichols, came to Ephrata and shot Sage Munro cold-blooded, without even knowing it, in the chest because he couldn't deal with the thought of Miranda, a Miss Messy, loving somebody else. Thank you.
I want again to express my personal thanks and on behalf of the parties, the lawyers, and everyone involved in the system for your long and careful work in this case. Ladies and gentlemen, you may retire.